I've tried to craft this up on the screen for you broadly in the order that we would think it might be relevant. Original trust, clone trust. We've tick, 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 we've satisfied all of the general concessions that you need to have satisfied, all the general rules that you need to satisfy. If having set up that new structure, you've got the clone trust go to the bank to borrow some money, you're going to have to analyse what that money's being used for. But if it is to acquire the business from the original trust, so in other words, the original trust is selling the asset back into the clone trust, then the nature of the borrowings or the purpose of the borrowings is going to have been income generating because you're buying a business. So in other words, that debt will be deductible. If you think about the cash flow though, the cash has come from the third party bank into the clone trust, and then as part of the sale transaction, you've then had the payment come into the original trust. So the whole lot of cash comes into that trust, and that will be, because of these provisions, it'll be a tax-free receipt. At that point, you can probably make I've styled it as an ETP, an eligible termination payment. I don't know particularly matters what it is, but you could possibly have that coming back to the original owner, say mum and dad, as part of an estate planning exercise. And then at that point, you would, as part of the succession plan, you would look to change the control of the original trust. So give the kids, for example, the control of the clone trust. Mum and dad keep control of the original trust, but they take the payment as part of that exercise. Creating deductible debt where there might not otherwise have been any access to deductible debt, and doing it in an entirely tax-free manner, and ultimately making sure that the kids, or kid as the case may be, are getting a completely clean-skinned structure as part of that exercise.